It's my privilege to give a twist to today's grand rounds. Rather than discussing research and clinical topics, we're going to talk about legal aspects of medicine. And I'm very happy to introduce Dr. Jeff Taylor. Dr. Taylor, welcome. A brief introduction to Dr. Taylor. So Dr. Taylor is currently an emeritus staff and a clinical emeritus cardiologist for Robert Wood Johnson University Hospital and also Somerset Hospital. He joined the clinical practice and has a long history. Briefly, let me go through that. He did his medicine from State University of New York in Brooklyn. Subsequently, his internal medicine from NYU, fellowship in cardiology from North Shore University, interventional cardiology from St. Vincent University. And subsequently, he formulated the Cardiology Associates of Somerset in 2000 with concomitant appointment at Somerset Medical Center. He was vice chair of internal medicine at Somerset Medical Center, medical director of the RWJ Somerset. He practiced as clinical cardiology for a pretty long time. Then he took a different angle to his world of clinical practice and clinical lifestyle. He obtained his MBA in 2015 and subsequently in 2023 decided to go to law school. Subsequently, after his completion, he is currently CEO and owner of the Cardio Core. His private practice is incorporated within the Barnabas Health System and was incorporated as part of the physician enterprise. He has focused on quality, policy, contract negotiation, compliance, medical decision-making, vendor negotiation, and most importantly, he has also participated in community service through a federally funded a free clinic in Manville, New Jersey. He continues to have excitement about educational initiatives, and he reached out to us that he's really interested to provide more education about different legal aspect of medicine, which we often do not provide education to our trainees and also our faculty and clinicians. He has won the Health Law Award of Excellence recently, and I thought it was amazing to hear his journey. And I requested him that as he gives this talk, he tells us what inspired him to take this turn in his career and how this could potentially also invite and stimulate some of us who may have alternate pathways that they could pursue in their own career as clinicians. With that, Jeff, the floor is yours.
Thank you. Hello, everybody. So I guess the first question is just to talk about what inspired me. So I've always wanted to become a physician, and I indeed was in clinical practice for about 25 years. In 2008, I opened up my own practice and soon realized there were a lot of business decisions that needed to be made. Should I purchase a nuclear camera? Should I buy an ECP machine? And I really didn't have any way of evaluating these business-wise. So I kind of made decisions. Fortunately, they worked out well. But in 2015, I decided, you know what, I want to get my MBA. There's a lot of medicine is becoming more corporatized. Those who have a business degree will be able to advance, I think, not only the business of medicine, but the clinical and quality aspects of medicine. So I applied to University of North Carolina. They did mostly online, but there were some in-person requirements. UNC's program, I think, is ranked 13th best in the nation, and they only accept people who have 5 years of experience or more in the field already. I will tell you that I gained a big respect for business people who went on and got their MBAs. Out of my long educational journey, I will say the business degree, the MBA, was the toughest out of all three. which I know is shocking to probably a lot of people who have MDs, myself included. But there was some advanced statistics, advanced analysis, a lot of really tough classes involved. Subsequently, as the years progressed and got tired in solo and for a few years, two-person private practice, I noticed as you get older, you get woken up in the middle of the night, you don't really get back to bed. Even, especially as an interventionalist, we took call in 1 week blocks. You know, you could be called in Tuesday, Wednesday, Thursday, and by Friday, you know, in your mid-50s, you had difficulty even moving. So what I decided to do, I've always wanted to learn, to go to law school more for the academics and the learning opportunity. So I went in and just said, I'm going to take the LSATs and see how I do. If I do good, then I'll apply to law school. One of my patients had told me that Seton Hall Law offered a weekend program. So every other weekend, Saturday from, I think it was 8 until 5:30, and Sunday from 9 until 3. And that was every other weekend for 4 years. And you could become a lawyer. So I took the LSAT, scored well, got offered a 50% scholarship, and said, you know what, I'm going to go. And I will tell you, I met some of the best friends of my life in law school. Unfortunately, in my last semester of law school, we were involved in a horrific car accident where we were hit head on by a driver who crossed the double yellow lines trying to pass the person in front of him. I was in the hospital here at Robert Wood and subsequently rehab for about 4 months. And then when I went home, needed to learn to walk and move and everything. I went to my last semester in law school with a peg, 2 JPs, and an ileostomy, walking with a cane to get to class to take my last 2 classes before my previous classes went what they call stale, which means they were no longer applicable towards a degree. One of the reasons I went to law school is because I realized that in order to make change and talk to attorneys, you have to be one of them. I was gifted with the opportunity to talk to the Attorney General of New Jersey at the bar conference, State Bar Conference in Atlantic City several years ago about the drug crisis and how it was their way of addressing it was really just having physicians not write pain medicines anymore. And I was able to give him a unique perspective on that. There are some really crazy policies in New Jersey. For example, in New Jersey, Medicaid does not cover insulin prepackaged syringes, and homeless shelters will not let patients in homeless shelters with needles. So if you have a homeless diabetic, essentially, that person needs to decide, do they want to sleep on the street or do they not want to take their insulin? One of the policy things I was interested in and still am is getting police officers to carry EpiPens. They're often the first on scene. We have teachers have them, but we didn't have a mandate for police officers to have them. I think that's insane that, you know, if a little baby gets stung by a bee or someone gets stung by a bee, they need to wait for the ambulance to come, which may add several more minutes than the police officer. And it could be a difference in life and death. So you may say, these policies sound like no-brainers, and I said that as well, but there's a lot of networking you have to do behind the scenes with politicians and attorneys, and it became clear the only way to do that is to become one of them. So I went to law school, and I decided I wanted to do this talk on 3 of the things that can really burn physicians, which are False Claims Act, Anti-Kickback, and Stalk Law. Oh, okay, you share the screen? Thank you. Oh, there we go. This is screen 2. And then share. Yeah, it's not sharing.
We can
And
see your slides. I think just has to be put on
And just if you could hit
slide show. Yeah, thank you.
Right, they're seeing the screen now.
You can see the slides now?
We can see the slides, put it on a slideshow.
Yeah, can we just go to from beginning? Perfect, okay.
And just change the display setting to go down one time and swap above one. Perfect, thank you.
Okay, great. So like anybody who's gone to law school, my disclaimer is no part of this presentation is intended to provide medical, legal, or business advice. Consult the appropriate professionals as needed. And I do need to make a disclaimer that I'm not admitted to the bar in any state. I've not taken the bar exam. And that's required by the ABA to say. What I've done is I've shortened some of the facts in the presentation. Nothing is factually inaccurate, but some of these laws are 40, 50 pages long. So obviously we'd never get anywhere if we went through all 40 or 50 pages. So I've tried to make the legal language English. So I think before we start out, we need to know that there are two types of fraud. And there's civil fraud and there's criminal fraud. So in order to have any fraud, you need to make a false statement or conceal a relevant event or relevant fact. And that has to induce reliance by the victim. So the victim has to rely on what you've told them, and the reliance is justifiable, and there needs to be damages. So what does that mean? You're submitting a claim. Let's say you submit a claim falsely to Medicare. You've submitted a false statement. You've induced reliance by the victim, the government, and they acted on that reliance. They paid the claim when they shouldn't have, so therefore damages had occurred. Now, the difference between criminal fraud and civil fraud is civil fraud has a mens rea requirement. And so you may say, what the heck is a mens rea? And hopefully I'll be able to get this to work. Okay. Here we go. All right, so this is a nice little way of remembering mens rea.
Ms. Woods, you may begin your questioning.
First of all, I would like to point out that not only is there no proof in this case, but there's a complete lack of mens rea, which by definition tells us that there can be no crime without a vicious will.
I am aware of the meaning of mens rea. What I'm unaware of is why you're giving me a vocabulary lesson when you should be questioning your witness.
So mens rea essentially can be used interchangeably with the word intent. My buttons are not working. Okay. So when people talk about mens rea, we're talking about intent. So if you go back and remember, criminal fraud requires intent, and it's very difficult to prove in many cases unless it's so egregious intent. So many times criminal fraud cases are not pursued, but civil frauds are much easier to prove because they do not require an intent. So you can commit civil fraud without intending to commit fraud. Fraud is big business. The False Claim Act enforcement brought in $2.5 billion in 2016, and that number's just kept going up. In 2024, it brought in $2.9 billion. So the False Claims Act enforcement is bringing a lot. In fact, the Department of Justice had made the statement several years ago that they considered physicians to be amongst their highest targets. The other thing is that in the False Claim Act, there's a 6-year statute of limitations. Now, why is that important? Well, what happens is, let's say Medicare audits one chart, and they say, well, you know what, you build this as a 99215, the highest level, and we think it's a 99214. What Medicare will do is they will not downgrade you to a 99214 and ask for the money back, the difference between a 4 and a 5 back. They will say, you coded it wrong. We want all of the 99215 money back. Now, if this occurs within a year and you're lucky enough, you can then submit a claim for 99214 on that same patient. Often, though, it occurs further than a year out. Medicare will only accept claims for a year. So what they can do is they can take the money back for 6 years, but they'll only pay you for 1 year. So the False Claim Act, and this is for anybody who wants to know and look up the actual act, is a person has to knowingly present a false or fraudulent claim for payment or approval. So right now everyone's saying, well, I'm never knowingly do that. But we'll examine what knowingly means in a moment. They need to knowingly make, use, or cause to be made or used a false record or statement that's material to a false or fraudulent claim. They could conspire in the above. Important thing is the False Claim Act only applies to government payment plans. So anytime federal healthcare dollars are reimbursed or paid to the practitioner, that's a government claim. So you cannot be brought up on a False Claim Act charge by Aetna because you've submitted wrong claims. There are other things they can get you on, many of them in your contract, and things like mail fraud and things like that, but not a False Claims Act. The penalties are steep. Criminal penalties can apply, meaning fine and jail, but the civil penalties can be tremendous. The civil penalties are adjusted yearly for inflation, and in 2016, they ranged from $11,000 to $21,513. What really gets you, though, is what's called treble damages. Treble damages are basically punitive damages, and they're usually a fine of 3 times what the government paid to a claim. So if you got $150 for a 99214 and Medicare thought it should be a level 3 visit, they can go and not only take the $150 back, but ask for $450 in treble damages. Now, what does knowingly mean? Remember I said that here's where legal and dictionary mean different things. So knowingly is a term of art. You can have actual knowledge of the information, which everybody would think, hey, that's the dictionary definition. Or you can act in a deliberate ignorance of the truth or falsity of the information. Or, and this is where you can get burned, you can act in a reckless disregard of the truth or falsity of the information. No specific intent to defraud is required. So even if you don't intend to defraud the government and you make honest mistakes on your claims, the government can go and say you've acted in reckless disregard of the truth. You haven't taken appropriate courses on how to code. You don't need to intend to defraud the government in order to knowingly defraud the government for civil cases. The Yates memo, and they call it the Yates memo because it's named after then Attorney General Yates. The civil investigators were told to share any information they collect with the criminal division. Now, what does that matter to you? It means that even if you are the subject of a civil investigation by, let's say, Medicare or the Office of the Inspector General or the Department of Justice, they will share or may share information with the criminal division, and anything that you potentially have said in a civil investigation, if it's damning to you, can be used against you in a criminal investigation. The investigations occur concurrently. The government is not under any obligation to tell you that there is a criminal investigation also going on. And this Yates memo directed the Department of Justice to increase its focus on individual participants in corporate fraud cases. So not just the corporations. Up until the Yates memo, the corporations were gone after, big corporations. But now the people who run these corporations as well, the presidents, the CEOs, the medical directors, they can be held liable in fraud cases. Just as an aside, a criminal investigation can only share some information with the civil division, and that has to do with your rights in criminal cases. There was a 2009 amendment included to the False Claim Act to include what's known as reverse false claims. Means if you knowingly retain government funds that were erroneously paid, and remember what knowingly means, you can be held liable under the False Claim Act. And the ACA, the Affordable Care Act, or Obamacare, added a 60-day payback rule. So not only if you retain the government funds erroneously paid, you're required to pay them back within 60 days, or you can be gone after for false claims. In addition, the False Claims Act, and this is more important to people who run institutions and big groups, the False Claims Act allows for what's known as qui tam claims. These are essentially whistleblower claims. It's a lawsuit brought by a private citizen on behalf of the government to recover money fraudulently obtained by a person or corporation. And the person bringing the suit can recover a portion of the funds, typically 15 to 30% of the funds recovered. So what that means is, you're working for, let's say, a private healthcare group or a private institution or a private hospital, a private nursing home, and they fire you and you're aware that, hey, maybe they're not on the up and up on all their claims. You go to the government and say, hey, this nursing home is not billing correctly. They open an investigation and recover millions of dollars. You're entitled to 15 to 30% of it. Now, this in and of itself, I'm oversimplifying this tremendously. It has to do with whether the government has brought an investigation. The government has to first deny, has to first say they don't want to investigate and let you proceed on their behalf. There are a lot of rules involved in this. I'm drastically oversimplifying it. But the qui tam claims can become a problem. They essentially are trying to turn employees into whistleblowers to go after companies. What I like to do is solidify a lot of these concepts with actual claims, so you can remember the concept tied to a claim. So in the U.S. versus Krisak, this was a U.S. district court that was tried in 1994. It was a civil action brought against a psychiatrist and his wife who was doing the billing for the psychiatrist. The government alleged the psychiatrist was engaging in unnecessary medical services, so inpatient care was provided when care could have been outpatient, as well as upcoding their visits. The doctor's wife billed 45 to 50 minutes of therapy for the vast majority of his visits on assumption. Sometimes, when the government looked at it, the doctor exceeded the number of hours in a day based on the billed time for counseling. So could you imagine that you've added up all the claims put in for the doctor for the day, and it turns out that he was counseling 29 hours a day? Well, the government was unable to prove the doctor engaged in unnecessary medical care, and this is often difficult to prove. It typically becomes a battle of the experts. But the court did find, the judge found that the doctor utterly failed to supervise his agents, his wife, his biller, his employee, and he therefore was responsible for violations of the False Claim Act for failing to supervise his employees. This case was back in 1994. The court felt very sad for the doctor. His claims would have been, in the hundreds. He only made $120,000 to $140,000 a year. They came out in a lot of what they found and said, oh, this is ridiculous. The Medicare billing is way less. The Medicare payments are way less than they should be. And they felt remorse for the doctor. So they did not subject him to these huge treble damages. But this was 30 years ago. That would not be the case today. One of the things the government does is they do statistical sampling to prove liability. And the here is USX Rel Marlin versus Life Care Centers. Now, there were 150,000 claims involving 55,000 patients. Obviously, there is no way the government could go through all of these claims and all of these patients and try each one of them. The plaintiff, meaning the government, argues that we should take a smaller representative sample and extrapolate the data to a larger population at hand. There have been conflicting district court precedents. No court of appeals has ruled on whether this is legal or not. And it's an issue of balancing fairness and public policy with due process. Now, this has never been applied in a criminal case. You're allowed in a criminal case to address each and every charge against you. But in civil cases, it's increasingly being allowed by the courts. So let's put this in perspective. Medicare audits you and they ask for 50 charts. You turn around, you send them in 50 charts and they say, you know what, out of your 50 charts, 5 of them were overcoded. So you have an error rate of 10%. You saw 4,000 patients last year. And so we're going to assume 400 patients were billed in error, and we want money back on 400 patients, and we want it in 60 days. And we're going to give you treble damages for improper claiming of 3 times the amount of money. You could rapidly see, especially if you're an internal medicine doctor and you're making $150,000 to $200,000 a year, some astronomical claim like that, and they can go back 6 years, could easily bankrupt you. I'm not sure whether I still debated whether I wanted to put in materiality. This is just more of an interest than it is 100% need to be known. But False Claim Act liability can arrive even if the requirements were not specifically designated as a condition for payment. And if requirements are specifically mentioned, not every violation of that gives rise to liability. A violation of compliance with a requirement has to be a material decision for the FCA, False Claims Act violation to occur. So one of these cases, Universal Health and a qui tam claim, staff members went in and misrepresented their qualifications to the government to get NPI numbers and then billed Medicaid for services of a psychologist, even though they were not psychologists doing the service. They were non-licensed, simply trained staff. The claims that were submitted, therefore, are material inaccurate. They don't just ask for payment. The court said they're half-truths. They're half-truths because they're saying a psychologist. They're making the assumption that a psychologist did the appropriate billing at an appropriate level, when in fact it was not a psychologist. And the interesting thing on this, it was a qui tam claim in that the patient's family brought the claim when they found out that the patient, who was an inpatient in this center, was not actually getting psychological counseling, but was being counseled by just regular nurses' aides and whatnot. So it's kind of interesting how the family brought the claim, but it's also interesting how you can get caught up by having a material defect in the claim. A claim for medical services also, we talked about False Claims Act must not only be, a claim for medical services has to be deemed not medically necessary, but also objectively false under the False Claim Act. So one of the reasons in the first case, the Krizak case that I talked to you about, the government failed in proving its claim that the doctor provided inpatient services that were not warranted, is because a False Claim Act is not simply a medical difference of opinion, that the government could come in and bring a doctor and say this is a medical difference of opinion. This is a fraudulent case. A medical difference of opinion does not mean that the case is fraudulent. It just means that one doctor felt one thing and another felt another, which is one of the reasons why it's difficult to prove that you're providing unnecessary medical services. There are ways that you can avoid government sanctions, or at least lessen government sanctions, by entering into settlement agreements. So let's say you're the medical director of a big clinic and it comes to your attention that one of your doctors is erroneously billing high-level visits where none existed because they're paid on productivity and they wanted to increase their own productivity. Well, you can just stay quiet about it, get rid of the doctor and hope that nothing happens. Or you can attempt to enter a settlement agreement. When the Department of Justice enters into a settlement agreement, the OIG can also enter into a corporate integrity agreement, which provides continuing oversight, compliance, reporting obligations, typically can include hiring compliance officer, developing written standards and policies, training employees, getting independent reviewers to provide audits, establishing a confidential disclosure program, restricting employment of ineligible persons, reporting overpayment, providing annual reports to OIG, all the cost borne by the institution, not the government. So settlement agreements are not the be all and end all that they can seem, but many times they'll result in less fines and less treble damages. This one's really going to be a kick in the head. Violations of what I'm going to talk to you next about the anti-kickback statute or the stalk law can and often does form a basis for a False Claim Act violation. So if you're involved in a kickback scheme or a violation of the stalk law, you almost definitely are involved in a false claim violation, because think about it, you're submitting a claim that should have never been paid, and what's happening is it's a False Claim Act violation. So not only are you going to be held liable under either stalk or anti-kickback laws, you're also going to be held liable under the False Claim Act and be subject to civil damages for that. The anti-kickback statute prohibits paying or receiving any remuneration, either directly or indirectly, overtly or covertly, in referring an individual to a person for the furnishing of a service reimbursed by the federal health care program, or in return for purchasing, leasing, ordering any good, facility, or service for which payment is made by the federal health care program. The anti-kickback statute is not limited to physicians. And by not limited to physicians, I'm not saying, oh, nurse practitioners and PAs. I'm saying it's not limited to physicians. It can involve drug reps. It can involve device reps. It applies to any person in a position to recommend or refer, and includes remuneration to patients even, such as routinely waiving copays. So you routinely waive copays, it's thought of as a remuneration to patient, and it's a violation of the Anti-Kickback Act. And I mentioned it can include drug or device companies. Now, what I did in practice, being aware of this, it doesn't say you can't waive copays to patients. It says you can't routinely waive copays to patients. So what I would do is I would put a note in my billing computer. If I knew a patient, was living on a very fixed income and had limited resources and maybe got $800 a month from Social Security and lived in a rent stabilized apartment and got help from the government for their phone bills and electric bills, I would put a note in the billing computer so that if I was ever subject to an audit, I could say, look, this is an exception patient. I'm not routinely waiving copays, but this lady lives on $800 a month. She clearly can't afford a $25 copay, so I'm seeing her as a courtesy. That you're allowed to do. That's not a violation of the anti-kickback regulations. Waiving for physicians is a violation of the anti-kickback provision, especially if they're in practice and they refer to you. The penalty can be $50,000 per violation plus treble damages up to 3 times. Again, no intent is needed. In a civil action, and this is important to talk about, the standard of proof is a preponderance of the evidence, where in a criminal violation, the standard of proof is beyond a reasonable doubt. So a preponderance of the evidence just means that you're 51% sure that you violated the Anti-Kickback Statute or the False Claim Act in a civil issue. So you don't have to have beyond a reasonable doubt, which is a much higher standard. Because of it's a higher standard, anyone who is guilty of a criminal violation is by fault guilty of a civil violation. But anyone guilty of a civil violation is not necessarily guilty of a criminal violation, because you have to prove a higher standard in a criminal violation. In a civil violation, it can involve exclusion from federal programs, and this can include persons with an ownership or control of the entity who knew or should have known that a violation was occurring, and office or managers, even if they didn't participate in the wrongdoing. So in a civil anti-kickback case, the head of a device company, the head of a hospital, the CEO of a hospital, the CFO of a hospital can be excluded from federal programs. And this essentially is going to end their career, and the exclusion can be up to 5 years. In a criminal case, there's a mandatory exclusion. In a civil case, you may be excluded. So there's a lot more discretion. There's no qui tam private right of action in anti-kickback. So whereas in the False Claims Act there was, in the anti-kickback there is not. But as important as I said is an anti-kickback can trigger a False Claims Act violation, and therefore there can be a qui tam. You can bring a qui tam claim for the False Claim Act. So the government you could bring the claim. The government says, "Hey, this is an anti-kickback." It automatically triggers a False Claims Act. And you're still, as a whistleblower, getting money for the False Claims Act fines. Now, there's a self-disclosure protocol as well. The upsides is you can avoid exclusion from federal healthcare programs without a corporate integrity agreement. And you can toll the 60-day rule for overpayment. Tolling means you're extending it. So once you self-disclose, that 60-day period stops and doesn't start again until the government has accepted your self-disclosure. There's typically lower penalties and lower treble damages, usually about 1.5 times the amount. But the downsides is there's uncertainty over the process. You will pay a penalty of at least $50,000, and the likelihood that OIG, the Office of Government Investigation, will launch an investigation into you. The Third Circuit Court of Appeals, U.S. versus Grieber. Now, this is important in cardiology grand rounds. I wanted to bring this case up. Grieber was a cardiologist, and he performed Holter monitors. And what he did is he performed the Holter monitors. Physicians, internal medicine, family doctors would send the patient to Grieber for a Holter monitor. Grieber would perform the Holter monitor, bill the global, forward the results of the Holter monitor to the referring physician. The referring physician would provide the interpretation and counseling of the patient, but rather than bill the interpretation fee of the Holter monitor, Grieber would give that doctor money out of the money he got from the global billing. The court found fault in that. The interpretation fees that Grieber was giving to the reading physicians were greater than the Medicare reimbursement for interpretation. And the court said even if the physician interpreting the test did so as a consultant, and in some cases there's evidence that the doctor really didn't interpret the test, Grieber did everything and was paying, but even if the doctor did interpret the test, so the consultant was paid the appropriate amount, if the purpose of the fee was to induce the ordering of the services, it violated the anti-kickback law. So even if this arrangement occurred on the up and up, if the purpose of doing this was was to get services, it violated the anti-kickback law. And think about, I guess a decade ago now, everyone was putting echo in, maybe not everyone, a lot of doctors were putting echoes in family doctors' offices. And the government will look at that and say, if the purpose of that echo in the office is to generate referrals for echoes, and they would pay a lease to the doctor, then that is a violation of the anti-kickback law. Now, because it's in the Third Circuit Court of Appeals, just to give you a little legal background, any court within the Third Circuit Appeals needs to follow Grieber. But if you're outside of the Third Circuit of Appeals, so if you're in a different circuit, the Ninth Circuit, whatever, Grieber is not dispositive. You're not required to follow it, but it is persuasive. Courts have taken various approaches to Grieber, but the OIG, when doing an investigation, has been following the Grieber standards. Some courts have taken a more strict rule on Grieber. Some have had a little more lax rule on Grieber, talking about the materiality standard playing a much larger role in what I talked to you about earlier. We don't need to go into this anymore in the legal end of it, but it's very interesting that, and you should always remember, if the purpose of the fee was to induce the ordering of the services, it violates the anti-kickback. Now, there are safe harbors. What a safe harbor is it's designed to protect from criminal and civil penalties certain arrangements that would otherwise be illegal. Safe harbor rules provide the rebuttable presumption that what you're doing is legal. And notice I said it's rebuttable. It's not, you think it's not wrap me up in a blanket. No matter what, I'm guaranteed not to have committed a violation. but it does give you a rebuttable presumption. Now, because of the time on the talk, to reproductive, there are 28 safe harbors. We're not going to go through all 28. We're going to go through, in fact, a few of them. To be protected, one must satisfy all the requirements of the safe harbor. If you fail to satisfy all of the requirements, though, it does not necessarily make the arrangement illegal. The courts will look at the facts and circumstances of the safe harbor. So some of the safe harbors, space rental. You need a written lease. It has to be not less than 1 year of duration. It has to be for fair market value. There has to be a reasonable aggregate space that you're leasing. So if you're leasing space in a physician's office that's 30 miles away, let's say from Robert Wood, because you want to provide cardiology services out there and make it easier for the patient, and you're a single doctor, you can't lease 10,000 square feet. You can only lease the amount that is reasonable. Similar personal services management contracts need to be signed. They need to cover all the service that the agents provide. They need to be not less than a year. The compensation needs to be set in advance and not based on referrals, and they have to be reasonable and necessary. If you're an ambulatory surgery center, the money collected is treated as a dividend and not remuneration. And it's okay to refer to an ambulatory surgery center as long as the referred patients are informed of the relationship you have. Gets a little more tricky if there's a multidisciplinary office owns an ambulatory surgery center. There are 7 standards that apply, and if a hospital's involved in at least ownership of the ambulatory surgery standard, there are additional 8 standards that apply. Remuneration doesn't include employee salaries, and hospitals can donate hardware and software and EMR services to the office without violating anti-kickback provisions. We're going to finish off talking about the Stark Law, which is technically known as the Ethics and Patients Referral Act, and it aims to protect patients and the federal healthcare programs from conflicts of interest arising when a physician stands to gain financially from referring patients to entities to which the physician or immediate family members have a financial interest. So, for example, my brother has a physical therapy business, a home physical therapy business. I would be prohibited from referring my cardiology patients to his practice for home physical therapy. That would be a Stark Law violation. CMS is the primary enforcer of the Stark Law. Overpayment has to be refunded in 60 days. There's a strict liability. This is kind of interesting. Strict liability. There's no mens rea requirement to establish a violation, but there is a mens rea requirement for administrative penalties. So if you violate, you can be found at fault, but you don't necessarily have an administrative penalty unless there's a mens rea. An arrangement that, and this with the safe harbors, an arrangement that fails to meet all of the requirements of an applicable exception has per se violated the law, and there's nothing you can do to save that as a safe harbor. Stock includes clinical labs, PT, OT, speech therapy, radiologic services, durable medical equipment, home care and hospital services, and prescription services. Common themes of stock, important themes, is that the physician compensation cannot vary or take into account the volume or value of the referrals, and compensation must be fair market value and commercially reasonable. This does not mean that you cannot be given bonuses as a physician. That is not a Stock Law violation. The fines are $15,000 per violation and up to 3 times treble damages for knowingly billing or failing to refund an overpayment in 60 days. You can possibly exclude it from Medicare. And there was a loophole in this until about 10 years ago. The loophole was closed. Physicians stand in the shoes of their physician organizations if they're owners, and maybe if they're certain employees. What that means is you can't get away from being a physician, owning a practice, and then saying, well, the practice entered into an agreement with the lab, not the physician, so I'm not responsible for a Stock Law violation. That loophole was closed by the last bullet point on this, and that was amended in the law. The advantages of a self-referral disclosure protocol to CMS is CMS may resolve the violation for less than the maximum penalty, although it may not, and it tolls the 60-day return. The risks are the Department of Justice and the OIG may get access to the disclosure can still impose sanctions under Anti-Kickback and False Claims Act. So even if you self-disclose and Medicare resolves the violation, it doesn't give you a maximum penalty, the DOJ can still come after you for a False Claims Act and seek the maximum penalty. There's also no appeals process under the self-disclosure protocol by Medicare. The stock test is typically not only does a direct relationship or does an indirect relationship. Both of those count in determining whether a financial relationship exists. And then you look at, is there an exception to the stock law? Very similar to the anti-kickback of rental of office space. The stock law includes that lease arrangements have to be commercially reasonable, even if no referrals were made between the leasee and lessor. The rental of equipment can't involve a rental charge, so you can't rent an echo machine and pay based on the number of echoes that are done. There are numerous other conditions, employment relationships and personal service relationships and works exceptions. It's very similar to the anti-kickback. I just wanted to quickly touch on the Foreign Corrupt Practices Act. And this is a little bit of an aside, but I bring this up because many times doctors who are American citizens may own hospitals or healthcare facilities in different countries. Even in owning a hospital, let's say you want a hospital built in country X, and it's typical that anybody who wants a hospital build may grease the palms of the administration and the government to get this hospital built, to get permits. Well, the Foreign Corrupt Practices Act prohibits U.S. citizens and entities from bribing foreign officials to gain business advantages. So even if the build or the process is outside of this country and in a different country, if you're an American citizen, you're prohibited from bribing foreign officials. Now, the 5 elements of bribing is paying something of value, involving a government official, having a corrupt motive. The goal should be to influence, induce, or secure an improper advantage and help to retain or obtain business. Now, why this is important is, what's a government official? The government of the United States has a very broad definition of what a government official is. Olympus Camera found this out when they were fined $646 million for violating the act for kickbacks or bribery in the U.S. and Latin America. What Olympus Camera basically did is paid doctors to influence purchase decisions of scopes, GI scopes in Latin America. And what they said is, when the government brought charges, they said, I paid the doctors. I didn't pay government employees. And the court ruled, since the doctors were governmental employees, as is the case in many, many other countries, they typically qualified as government workers. You lose Olympus. That's a $312 million criminal penalty and a $311 million civil penalty. So the government has a very broad definition of what a government employee is. What I'm going to do is just finish on telling you that there are many people who don't feel that the Foreign Corrupt Practices Act is fair, that it puts American citizens at a disadvantage in allowing them to do business in other countries where citizens of other countries can bribe officials. Donald Trump is one of those citizens. And whether you like him or not, he issued an executive order in February of 2005 pausing the Foreign Corrupt Practice Act enforcement. And his justification is to further the American economic and national security. I will caution anyone, though, who violates the Foreign Corrupt Practices Act this is an executive order, not a law. So it is possible that the next president that comes in can reverse this executive order. And if you are involved in bribing a foreign official, and I don't mean you as doctors, I mean anybody, you could subsequently be prosecuted for things that happen while Donald Trump is in office, but prosecuted after he leaves office for violating this act. And that is the end of the slideshow. I don't know how to go back to showing my face. Oh, there we go. Beautiful. So what I'd like to do is open up to questions if anybody has them.
Thank you very much, Jeff, for that very revealing discussion, which was completely different from the typical grand rounds we have. And I think you discussed many aspects. So I just would like to open the floor for people to pose any questions if they have. Let me start by asking a very question related to vendors. You know, we utilize a variety of vendors, and typically we have several times engagement in CME conferences. Could you explain when and what is a CME and sponsored vendors assignment versus where it starts becoming unclear? Because I think I just wanted to highlight at least our trainee and faculty of what practices they should be engaged in and what would be ethical and what would be constituting as some violation.
Yeah, so I think that really what it turns on a lot. So CME activities, even if they're sponsored by a vendor, are permissible. What determines it's more of a determination on whether you can get CME for the cost that you go to. And it depends, my understanding is who's sponsoring it. So if you are advocating for a specific device, then it is not a CME able event. You are able to use vendors in like the operating room. You are able to use them for you know, if they're going to bring in a lunch, there are regulations on how much money. I think a lunch is no more than $15 or $10 per person. You can go to an educational event, you know, educational dinner. You can't go to the Bahamas, you know, for a conference sponsored by a vendor. What they really do is they look at a lot of reasonableness. What is reasonable? But if the purpose of the conference, what I always do is I say, if the purpose of the conference is to promote the product, then, you know, it's clearly not a CME conference. It's a vendor-sponsored event. If the purpose of the conference is to educate physicians and, you know, you'll present a balanced view of the product. It doesn't say you can't mention the product. You know, you do something on laser, let's say in a cath lab. You know, there are pros and cons to laser. There are times when it's good to use laser, thrombus, soft plaque. There are times when laser does nothing, calcified lesions. So as long as you're presenting a fair and balanced assessment, then that's okay.
So Jeff, if I would summarize correctly, so if there are educational events or events, first of all, this cardiology grand rounds is not sponsored. This is sponsored.
Right. Or we wouldn't, yeah,
all
or the CME issue.
Free up any, yeah, CME, MOC credits. But I just wanted to make that a full clarity for everybody. The division sponsors this activities directly from research and educational funds that we get from our association with the health system and also the medical school. But
you're worried about the qui tam claims, aren't you?
we are basically, when we operate, we want to be completely fair and to all the processes, and it's very important that we do it the right way. But I wanted to mention to you, so we do educational activities or fellowship activities or faculty activities, and the product is not advertised, and or the person is who is sponsoring the event is not showcasing an advertisement, or there's no way in that event for the person. There may be an acknowledgement or thanking that thanks for sponsoring the event, but not beyond that. There is no applied. Would that be a fair way to justify events that are typically, and of course the reasonability and all those aspects are very important. I just wanted to make sure, because we want to be taking all this information also for the future as we plan, because this is a very uncertain period and we have to be extremely careful on how we engage with our facilities and also our fraternities and industry. Having said that, industry is a strong player of education and research in cardiology. So negligence on not being able to engage them appropriately is also a mistake. So we want to make sure that we are balancing the act in the correct way and ethically. So I wanted to bring that up.
Yeah, I think that, as long as, so first off, there are many things that, what you learn in law school is the answer is never, you never get an answer on what you ask. You always get the words depends. But I think if the main goal is for education, even if, let's say you want to do let's say you're doing a grand rounds on the new leadless pacemaker, obviously most of that is going to be discussed. And even if it's sponsored, that's fine. But, you would want to also say, look, I'm not just doing this to get people to put leadless pacemakers in because, look, my slide here shows the contraindications. And this study showed, they don't battery doesn't last as long. As long as you're fair and balanced, I think you're fine.
Yeah. So there's a question that is being asked by Sasha East, one of our non-invasive cardiologists. Excellent talk. Could you talk about undercoding? Can one still be fined just the same?
Yes. Yes, undercoding and overcoding, the government doesn't care. I will tell you about a funny story with undercoding. I had 2 Medicare audits in my practice in probably 10 years. And you can go online and get the Medicare audit tool that the Medicare auditors use. So I took my charts, I went through the audit tool, I stapled it on each chart they asked for, sent it to Medicare, I got 50 out of 50 coded correctly. I had a Blue Cross audit. They asked for 50 charts. I got 49 coded correctly. One chart, they said I undercoded. They said I billed it at a 99214 and I should have billed it at a 99215. And I saw the patient 3 months prior. Now, what do you think they did? They took all the money back from 99214. They didn't pay me for 99215. So I said to my billing people, resubmit it with a 99215. We resubmitted it and I got paid for 99215. But this should absolutely go into your brain that they will take the money back automatically, but they will not adjust what you should have got, even if it's a higher code. Or even if it's a lower code. If you build a 99214 and they thought it should be a 3, they'll take all the 4 back, but they won't process a 3 for you. Undercoding is also considered a false claim.
Interesting. So the undercoding is also considered a false claim. That's very, very important message. Wow.
Right. And you think about maybe it could be and I could argue probably if I had a person who was undercoding purposely, I could argue that perhaps it's an anti-kickback violation because you're billing Medicare less. So the 20% that the patient pays, now the patient has to pay less. So the patient is seeing me because I always bill a level 3 and they're not seeing you because you bill a level 4. So I'm inducing that patient to come to me by kicking back and making them pay less. So I think I would have a good argument on that. I don't think it's ever been argued on that. I would have to do a search in the law, but these are the things kind of they teach you in law school to start that. But I think that you can make a case for not only a false claim act, but an anti-kickback. Now if you do it one time, no one's coming after people for one time. The conspiracy theorist in me believes that one of the reasons the government is trying to get all these small private practices into these big conglomerates is they're way easier to audit. And when you make a mistake on the audit, the money that comes into the government back is astronomical. Like they go after one guy who does geriatrics who makes $90,000 a year. What are they going to get? Maybe a couple $100. They go after a group of 600, 700, 800 doctors. And they take, X amount of charts from each doctor and then extrapolate it up. You could be talking tens of millions of dollars. So that's just me thinking that there's a conspiracy theory, but I can't prove it, but it's one of the things that I've been thinking about for a long time.
So there's Lance Berger is asking a question. He's pointing out that in New Jersey, people have gone into prison for violating the anti-kickback statute, physicians.
Yeah.
points out there. And then Isam Kolita.
I should say, if you don't mind, Dr. Sengupta, I should say, due to limitations, most states also have laws that mirror false claims, anti-kickback, and stock laws. Some states are a little different, but many states have laws also, and you can get into trouble with the state as well, in addition to the federal government. So I just didn't, there's no way I could possibly talk about the nuances of New Jersey and, in 50 minutes.
Yeah.
But
no,
yeah.
Agree.
There are people in New York too, from having kickbacks from labs and stuff like that. I think those cases are, I know one of the doctor, I think that was ridiculous. He was getting like $300 a month, and he went to jail for I think 18 months during COVID for lab. Now lab, interesting, in New Jersey, you cannot pay a lab to be in your office. So that's part of their. I'm not sure if it's a law or if it's in the state board regulations, the licensing regulations, but you can't have it. Stock.
Hi, it's Lance Berger. I'm just
Hey.
following up with that. Yeah, so we had a couple of physicians in Monmouth County, who were receiving payments for that, and the judges had said to them, you had to know it was wrong to get an envelope of cash. And I think for those of you in training who are listening, and this is a really important lesson, that we all need to heed, that it's we stay to the side of the line that makes the most sense. And,
Yeah, no,
thank you for the
it's-
talk.
Yeah, and you're 100% right on that, right? If there's even a little thought of impropriety, don't do it. It's not worth it. If I told you some of these doctors who went to jail for prescribing Sufenta, which was nasal fentanyl, because they were they were given speaker fees and stuff. This is going back about 8 years ago. We had a lecture from the prosecutor, the federal prosecutor who prosecuted these doctors, and the highest paid doctor over 5 years made $220,000. And I raised my hand in class and said, this guy, 5 years, $220,000. He made like $45,000 a year. I think he was a pain management doctor. I said, his average, he's probably making $300,000-400,000. What's the extra 45 to these guys? But it's just stupidity. It's just stupidity, and they target people who, this guy was going through a divorce, and he was lonely, and a lot of weird stuff. But yeah, if it seems wrong, it probably is. It's not worth the little bit of extra money.
So there is a question here. I was told by someone, this is from Isam Kolialat. I was told by someone long ago that if one is not actively managing anything but continues to write daily notes on a console just to bill, that could be construed as fraud. Is that correct?
So that would turn on medical necessity, right? So if it's medically necessary, then it's not fraud. If it's medically not necessary, then it is fraud. So that would be a battle of the physicians. And I would say, look, you have a patient who's very stable, and you're loading them with amiodarone. Today is day number 3, and you're the consultant. You go okay to see that patient, right? Even if they're rock stable, you want to look at their QT, are they having any VT on telemetry? That's fine. If you're seeing the nursing home patient who had an MI non-Q wave 3 weeks ago and hasn't had any post-infarct angina or something and doesn't talk, and you're not really adding anything, maybe if you're titrating up beta blockers, that's fine. If you're adding ACE inhibitors, that's fine. If you're just writing the same note, cut and paste every day just to generate revenue, you're going to get into trouble with that. Now, again, 1 case, 2 cases, not going to, they're not coming after you for that. But if it's a chronic thing, I've had doctors write, no word of a lie, when they would write in the chart, some doctors, I'm not going to mention, but they would write in the chart, discussed with Dr. Taylor, and then they would bill it at a high level. I assume they're billing at a high level. I would see my name in the chart. So I would say, Jesus, this happened. I was on a cruise last week. How the hell did they discuss the case with me? So I don't want to throw them overboard, but I don't want to be responsible if something malpractice comes 5 years from now and the lawyer says, oh, you discussed the case. So I would write in my note, return
Yeah.
from vacation, appreciate doctor, whoever covered for me. And then I would summarize and I would drop it at that.
Let
But
me bring
crazy.
up, yeah, no, I wanted to just be mindful of the time, but I wanted quickly to discuss, let me bring now AI. Now notes are going to be created by AI. There are already pilots happening. I hope they're going to be accurate, but if there are hallucinations and things are inserted and you do not correct and you don't check for them, how do you account for them?
Yeah, I'll tell you, I'm more worried with cut and paste on when cases come to malpractice, when you've cut and pasted things, especially when you paste a note and it's got something that, we'll start amiodarone is in your note, and you started it 5 days ago because your first note said that. I worry very much about those malpractice cases. AI is being looked at in coding as well. I think one of the things, the best thing that Medicare could do, and I've been a big advocate for a long time, is, Medicare was looking before COVID to go to a time only. So 99211, 2, 3, I think 3, 4, or 5 paid the same amount. And you just, by the time you spent with the patient and doing chart review and stuff, and that's what you would bill. I, for a long time, thought you should take a specialty, cardiology, look at what the average billing amount is. Let's say the average is a 99214.2 or something. You get X amount of money for that, and you should be reimbursed when you see the patient. If you see the patient quickly, 5 minutes, you made money. You see the patient for an hour and a half in the ICU, you lost money. But if it's equating to the average, it's just going to make things so much better. I don't think we're going to get there. They keep talking about Medicare's delayed the timing to get rid of all these, check 4 boxes here, 3 boxes here, and just go to a time-based system. They delayed it because of COVID, and every time I look at it, it's delayed another year. But that was the way they were going.
Yeah. Great. I think different types of pressures, lots of uncertainties at the moment, but I think it's always important that we know about the rules and the ethics and the compliance that we need to follow. Really, thank you, Jeff, for this outstanding presentation. I think our trainees and faculty and physicians and staff must have really learned a lot. We look forward to continuing this discussion, hopefully on an annual basis, because it's good for our trainees to know something about new things that are happening.
Yeah, absolutely. And if I could just finish off by saying attorneys are expensive. So, you get into one of these jams, you're paying an attorney to represent you. If, against civil stuff, you're paying another one to represent you against the board. There's no way you're making the money that you're going to spend tens of thousands of dollars being represented. It's not worth it. Fly straight, and, you still may be audited, but at least you're doing right. And do self-audits in your office. Pull some charts, have one of your partners audit you and see if you're billing at the right level. Go to a coding class. It's not that bad. It's you may learn something that makes you more money. Those are all the things that I would recommend at this point. That's the stuff that I started doing, and it helped me immensely.
Thank you very much, and hope everybody enjoyed the talk, and we look
I
forward
hope so.
to continuing this discussion later on as well. Thank you.
Thank you very much.
Bye.